Supporters of a proposed amendment in Florida aimed at safeguarding abortion rights have cleared significant hurdles, such as gathering nearly 1 million petitions and securing approval from the state's conservative Supreme Court. However, achieving the necessary 60% voter approval in November is unlikely to be the final obstacle. Florida legislators have a track record of diluting amendments they oppose. With Governor Ron DeSantis and other top officials against the abortion measure, there's a possibility that the legislature might attempt to undermine it. This resistance isn't unique to the abortion amendment. Another amendment on the November ballot seeks to legalize recreational marijuana, which faces opposition from DeSantis and others. Jonathan Marshfield, a state constitutional law professor at the University of Florida, highlighted lawmakers' sophisticated strategies to counter initiatives they dislike. Outside advocacy groups opposing the amendments could also resort to legal challenges, potentially bringing the cases back to the state Supreme Court. Anti-abortion groups, such as Susan B. Anthony Pro-Life America and Florida Voters Against Extremism, downplay questions about potential legal challenges, expressing confidence that voters will reject the abortion amendment. Supporters of the amendment affirm their readiness to ensure legislators respect the voters' will when implementing it. Similarly, backers of the marijuana amendment pledged to work towards proper regulation if it passes. Despite voter approval, lawmakers can pass legislation to enact amendments in ways not anticipated by voters or advocacy groups. Examples include actions taken after amendments on school class size limits and medical marijuana were approved. Lawmakers can also influence amendments through the budget. For instance, funding for a high-speed rail project approved by voters in 2000 was eventually withdrawn by then-Governor Rick Scott. Lawmakers may reconvene in March next year, giving them the opportunity to pass laws affecting amendments approved in the current election cycle. Potential measures related to recreational marijuana could include THC caps or smoke-free zones. Steve Vancor, a spokesperson for the Smart and Safe Florida group sponsoring the marijuana amendment, indicated support for efforts to regulate marijuana consumption in public, emphasizing the legislature's authority in this regard. The future of abortion laws in Florida may face further legal challenges, potentially returning to the courts for interpretation. Despite the Florida Supreme Court's 4-3 vote to place the abortion amendment on the ballot, justices hinted at potential avenues for legal challenges by introducing the concept of fetuses' legal rights. This concept revolves around the question of whether fetuses should be granted the same rights and constitutional protections as individuals. Justice Jamie Groshans, in dissent against allowing the amendment on the ballot, argued that it does not resolve the abortion issue, instead deferring it back to the courts for interpretation of scope, boundaries, definitions, and policies. Chief Justice Carlos Muniz broached the idea of fetuses' rights under the Florida Constitution during oral arguments on the abortion amendment. Muniz reiterated this concept in a concurring opinion accompanying the ruling allowing the amendment on the ballot. Justices Charles Kennedy and John Curiel joined in the opinion, asserting that the amendment would prohibit individuals from using the law to shield an entire class of human beings from private harm. Groshans also suggested that the amendment could impact the constitutional right to life, a sentiment echoed by Justice Meredith Sasso and Justice Rena Francis, who argued that abortion infringes on the rights of another person. John Stemberger, president of Liberty Counsel Action, believes that if the amendment is incorporated into the Florida Constitution, conservative groups may face challenges in mounting legal opposition afterward. Stemberger's group is actively campaigning against the amendment, recognizing the potential difficulty of contesting it post-adoption. Michelle Morton, policy counsel for the ACLU of Florida, concurred with Stemberger, noting that if the amendment is enshrined in the state's constitution, advocating for additional rights for fetuses would become more challenging due to the amendment superseding older provisions, even with a new interpretation. She emphasized their commitment to continue advocating against the amendment.